If a licensee is going to obtain a copy of source code to the licensor's commercial software, what rights does the licensee have to use or make use of that source code after a copy has been obtained from Escrow? That's a detail that's ordinarily worked out in the Escrow agreement, and I would say that the answer is almost never to use the license that's contained in most standard Escrow agreements that the popular escrow companies provide. Lawyers chuckle at these documents a lot, not to poke fun at them too often, but they often say something like this: if a copy of the source code is obtained out of escrow after a release trigger occurs, then the licensee shall have a license to use the deposit materials to continue affording the benefits of the licensed software. What does that mean? These license grants are so vague that I really can't tell you what rights they grant to the licensee. That's not a good situation for either the licensor or the licensee. And so unfortunately, we find ourselves having to negotiate the license grant with the escrow company routinely. Fortunately, they're pretty receptive to this. I'd like them to change their templates, but this is a common question that arises, and it's commonly dealt with. What is the appropriate license grant after the escrow materials have been obtained by the licensee following a release trigger? Well, the answer is to be quite specific. Ordinarily, we have placed materials into escrow, placed the source code into escrow, and created this entire escrow arrangement so that the licensee will have the ability to support itself, to provide code maintenance in the event that the licensor is unable to provide that code maintenance and support. So we need to make sure that the license grant enables that. So we'd like to see a license grant that says something like the licensee has a right to use the source code and to modify it and to create derivative works of that source code, and then to compile the source code into an executable object code form, and then to continue using that object code form in the same way within the same scope of rights that it originally had the right to use the software. It's not an unlimited right to use the object code form. For example, if I had obtained a license to use the commercial software on 3 servers within my enterprise, then what I'd like the ability to do is obtain the source code in the appropriate circumstances, modify it as necessary to correct bugs, compile that, and then use it on 3 servers just like I had been using it. And so we need to have a license grant that enables that. It is always necessary to be specific. So a couple of things that should be considered, a couple of details. Who is going to have the ability to access and modify, edit, correct that source code? Well, remember, not all licensees are software companies, and they don't have in-house talent, in-house personnel who are capable of that. Imagine, for example, that you are a real estate company and you have invested substantial funds into a big enterprise software package, and for some reason the licensor becomes unable to provide support. In that case, the real estate company obtains a copy of the source code out of escrow, now wishes to support itself, but it might not have on staff appropriate personnel to do that. What's it to do? It might, for example, hire personnel from the licensor. Let's imagine the licensor had entered bankruptcy or wound up its business. It might simply hire those people, or it might hire people internally, or it might go outside of the company and engage a third party to provide those services. Well, engaging that third party and handing over the source code is a disclosure of the source code to a third party, and that almost assuredly is prohibited by the license agreement and the escrow agreement itself. And so if the licensee intends to rely on third parties to provide that support, then there will need to be exceptions to the confidentiality restrictions in order to enable that, and the license grant should enable that as well. Finally, do remember that the duration of the license being granted regarding the source code should at least be adequate to enable support for as long as the licensee is entitled to use the object code form of the software. If the licensee has obtained a perpetual license to the enterprise software, let's say, then it would be appropriate to obtain a perpetual license to the source code and to use that for so long as they continue using the object code form in their business. However, if the licensee has a limited term license, perhaps a 5 or 10-year subscription to use the commercial software, then it wouldn't be appropriate to give that licensee a perpetual license or even a longer license in the source code. Ordinarily, its license in the source code should be of equal duration. There are exceptions to this, of course. There is ordinarily a lag time, as I've just described, when the licensee has got to learn how to use the source code. Unless it is hiring the personnel of the licensor to come in-house and provide that support, the licensee may need to give its personnel adequate time to study the source code in order to get up to speed and begin providing support, or it may need to give the third-party vendor of services adequate time to get up to speed. It's often the case, therefore, that licensees will argue that there is a period of time where their productive use of the software is interrupted, and it would be appropriate for their license in the software to be extended as a result of the release of source code from Escrow, or of the circumstances giving rise to the release, and therefore it would be appropriate for their license in the source code to track that equally longer time. So we need to be specific when writing license grants regarding the escrow materials, and unfortunately the template agreements that are available from many of the popular escrow companies is just not specific enough. Write an agreement which contains all the verbs that are appropriate, allowing use and modification and creation of derivative works, recompiling of that software, and ensure that the uses are adequate to enable the party to support itself and support its already contracted for licensed use of the object code software. Be sure that the license is appropriate to enable in-house support or the use of third-party contractors if that's contemplated, and always make sure that the license grant is of appropriate duration so that the licensee can use its already licensed object code form of the software.